Good morning. Thank you for being with us. My name is David Horrigan. I'm the Discovery Counsel and Legal Education Director at Relativity, and I want to thank you for joining us this morning for our session on rules, regulations, and roles. The idea behind this session is that in the United Kingdom, in the courts of England and Wales, there is a movement adrift for some fairly substantial changes in the way disclosure is conducted. And we have a panel here today that's going to discuss those changes, how they may or may not come about, but also compare and contrast them to changes that we've seen in the United States and changes that we may be seeing in Ireland as well. And we're very honored to have a selection of experts to bring these ideas home to you and inform you of what's going on. First of all, starting at the end, we have the Honorable Mr. Justice Burse. He is the Business and Property Court Supervising Judge for the Midland, Wales, and Western Circuits. Mr. Justice Burse served previously as Justice of the High Court, Chancery Division, and a Judge of the Patent Court. He's also served as QC and Deputy Chairman of the Copyright Tribunal, Standing Counsel to the Comptroller General of Patents and Trademarks and Designs. Please join us in welcoming the Honorable Mr. Justice Burse. Mr. Justice Burse, of course, is part of the Disclosure Working Group. One of the fellow members of the Disclosure Working Group that is examining these potential changes is Ed Cross. Ed is partner at Simmons & Simmons, where he specializes in complex financial and regulatory disputes for the financial institutions in the financial industry. But in addition to that, he's the president of the London Solicitors Litigation Association, serving the over 2,400 solicitors in London as an advocate for them. He's also on the Disclosure Group. And one thing I've got to say about these two gentlemen is when I was talking about potential speakers for this session, I had no less than 3 people say, "You've got to get these two gentlemen." Please also join us in welcoming Ed Cross. One of those people who said you've got to get these two guys is Chris Dale. Chris Dale is an institution in international e-disclosure. If you are an American and you know anything about the English system, chances are you learned it from Chris Dale. He is the founder of the E-Disclosure Information Project and a longtime commentator on the state of e-disclosure and e-discovery across the pond. He also is a very good speaker for this session because in addition to teaching American audiences about the disclosure of England and Wales, he summarized the rules in a way that I think perhaps no one has done better. Read the blank rules, and we'll leave it to your imagination what the blank may be. Please join us in welcoming Chris Dale. Next to Chris is Karen Hardy, who is a partner at McCann Fitzgerald. Her principal practice area is complex commercial disputes. She has specializations in international law, regulatory and criminal investigations, and media law as well. But she is known around the world as the attorney who made technology-assisted reviews safe for the Republic of Ireland. In all seriousness, she is the attorney who argued the Quinn case that approved the use of technology-assisted review in Ireland. She's been a trendsetter in the law. We're honored to have her. Please join us in welcoming Karen Hardy. And finally, some of you may be wondering, rules, they're arcane, they may be boring. How can they apply to my life? Wendy King of FTI Consulting is going to tell you how they can apply to your life. You saw Wendy probably in the opening keynote. She is managing director at FTI Consulting. She brings quadruple experience to the session today. Not only has she managed litigation support in a law firm, she has been with a major software developer, this one, and she has also served with a major e-discovery service provider, and now, of course, she's with the global consulting firm FTI Consulting. So we're going to talk about these rules, how they've formulated in different jurisdictions, and Wendy's going to bring it all home for us. Please join me in welcoming Wendy King. Our agenda today is going to cover, as we talked about, the Disclosure Working Group. More importantly for this UK audience, what these rule changes may be and how they're going to affect you. Mr. Justice Burse and Ed Cross are going to give us an introduction on what the rules could be and what these changes could be. Chris Dale, of course, is going to comment on them as well. We'll move over to Ireland and have a little bit of comparing and contrasting, and then Wendy and I will join with the United States talking about some of the amendments to the Federal Rules of Civil Procedure, and we'll talk about the various topics, be they sanctions, more or less, what's a good thing, and once again, how they're going to affect your practice. Why don't we begin with Mr. Justice Burse?
Well, thank you very much, David, for that kind introduction, and thank you to Relativity. I'll make a confession, which it's going to cause me to be kicked off this panel instantly. I'm afraid I'd never heard of Relativity, but I now have, and now I know who they are, and I'm sure other providers are available. I have to say that because I'm a judge, but they're obviously involved in this quite a lot. What I'm going to talk to you about with Ed particularly is the work we've done on this disclosure working group. A little bit of background. It all started when the GC 100, which is the group of the General Counsel for the FTSE 100 companies in London, in England, approached the Master of the Rolls about civil procedure in general and disclosure in particular. And they raised a concern from the perspective of commercial litigants, and that's whether they're claimants or defendants, about the disclosure process, the cost, the complexity, and whether it was really doing what it needed to do. And that led to a big discussion. There was a big meeting in the Rolls building in 2016, led to a working group being set up under the chairmanship of Lady Justice Gloucester. The group includes myself, it includes Ed, and a number of other people. And it's been working really very hard in the last year and a half, 2 years, to try and come up with proposals to do something about disclosure. There are various perceived problems, and Ed and I will discuss some of this in a bit more detail in a minute or two. But the essential problem, I think, can probably be summarized in this way. The feeling that we received as a working group from a wide range of business litigators, including solicitors, obviously barristers, and also clients, is that although there was a significant change in the civil procedure rules not that long ago about disclosure, which came out of Sir Rupert Jackson, Lord Justice Jackson's review, which introduced standard disclosure and a menu of options, the practical reality was, and is, that menu isn't really being used. The practical reality is that every case, more or less, goes straight to one option off the menu. It's a bit like giving everyone a menu, and then everyone picks lobster. They pick the most expensive option on the menu, and no one is choosing all the other good things that are there. And one of the key ideas behind what is being proposed is not to take lobster off the menu. It is absolutely not. To get rid of disclosure, to make it impossible to have a full, very detailed disclosure exercise if it's appropriate, but it's to allow for a system, to create a system where disclosure is made to be appropriate for the case. And then that applies in different ways. But one of the fundamental ways is to try and encourage the parties much more than we've ever done in the past to actually discuss it between themselves, to engage with each other. And that's something that I know Ed will speak about. But also to try and get the parties at an early stage to focus on the issues in the case and onto what issues the disclosure is actually about. Because one of the perennial difficulties seems to be, from what people have said, is that disclosure is done on a blanket basis across every conceivable issue before anyone has ever really thought out whether you even need to search for issues on disclosure documents on X and Y or Z. And so those two key things are really driving what's proposed. The working group has met many, many times. Some very serious drafting work has been done. The plan is to get a draft pilot system to work in the business and property courts, which is the courts in the Rolls building, and if it's possible, have it up and running sometime later this year. That may or may not be possible, but that's the aspiration. To work it as a pilot and understand how it works and see where we go from there. And with that introduction, I'll hand you over to Ed.
Thank you, Colin. It was an interesting experience right at the start when we set about this and we had that initial meeting that Colin referred to, where solicitors, barristers and judges and clients turned up to say, well, what is it that could be improved about disclosure? Why is it not achieving the objectives of Lord Justice Jackson? And there was a lot of finger pointing. The solicitors profession discreetly but quite obviously pointed fingers at the judiciary and said, well, the rules are there. Why aren't they being used? Why aren't we getting more robust cost management by case management by the judiciary? The judiciary responded, well, all the rules are there. Why is it the parties don't talk to each other? Why don't they present us with the information that we need in order to make a bespoke and informed decision on disclosure? We can't do it in a vacuum. And that is the reality, is that under the current system, even though you have an obligation to complete the EDQ, and even though the rules require you to cooperate, the parties are not doing it in practice. And I think it is fair to say that it hasn't always been stamped on by the court as being an unacceptable outcome to arrive at the first case management conference without having really discussed, as Colin says, what are the issues? How are we going to go about disclosure? How big is the problem? How can we tackle it efficiently, in particular using technology? And what type of orders do we want in relation to particular issues? And those discussions just are not happening. What you have instead are reams and reams of correspondence where the parties position and they hope that that's going to somehow influence the decision on the day. But the reality is the default is often that the parties just ask for an order for standard disclosure, which, as we all know, is a very broad order, and it doesn't always result in production of just the most important documents. And we've had some cases recently, very helpful cases, reinforcing that technology, and this is where you all come in, can really make a difference and is being recognised by the judiciary. But if you look at Part 31, there's not enough in there to really structure how technology might be used and to provide a structure in particular for parties that may be less sophisticated in going about an e-disclosure exercise. So we thought we'd try and change that part of it. But starting right at the beginning, one of the biggest things that was fed back was that we need to change the culture and approach of litigants to disclosure. Because naturally, it's a very adversarial process, and each side will be pushing for the broadest possible disclosure so that the other side can't sit on that smoking gun, so that it's discovered. But that doesn't always achieve the most just and proportionate outcome. So we felt that what was needed in order to change behaviours were a set of very clear duties set out in the proposed practice direction that would explain to clients and separately to legal advisors what is expected in relation to disclosure. Now, none of this is rocket science, but I think it is helpful to have it expressly in the rules. So you will find, obviously, a duty to preserve documents, that everyone knows. A duty on clients and their lawyers to act honestly. Well, that raised a few eyebrows, but actually, when I have had clients from some jurisdictions where the idea of cards on the table isn't perhaps something they feel very comfortable about. And it is helpful for me as a solicitor to be able to turn to my client and say, no, I have a duty to act honestly, and you do too. We are going to disclose those documents you've now shown to me. A freestanding duty to disclose known adverse documents. Well, Colin will come back to this, but this is the point that if you're pursuing litigation, you shouldn't be allowed to sit on a smoking gun, which you've discovered, which is inconsistent with your case. That's quite a tricky one. An express duty not to dump documents on the other side. We've all seen it happen. It's a tactic. Particularly if the other side is not particularly well funded, is to send them an amount of materials, only a small fraction of which will be relevant, because they ask for lots and they get lots, but it's not very helpful. So there'll be an express duty to deal with that.
Ed, if I could ask you a question on that. On the document dumps, in the United States, we have issues back in bygone days where documents were produced on red paper. Why red paper? Because it couldn't be photocopied. And then there's the document dump. If they want the kitchen sink and everything else, we'll give it to them. Is that not currently prohibited under the rules of England and Wales?
Well, it's certainly frowned upon, and there have been a number of decisions where firms have been criticised for doing that, where it was quite obvious from looking at the selection of documents that there were documents in there that plainly had no relevance to the issues. And that has to stop. But I think it is a practice, but having an express duty to remind parties they shouldn't be doing it is, I think, going to be helpful.
I think, David, the simple answer to your question is that the English legal system assumes that everyone is a gentleman. And one of the things that we've realised we have to do with the duties, as Ed's been describing, is write down what the duties of a gentleman actually are.
But there is power to punish the sort of activity you've talked about.
I was waiting for that interjection, counsel.
And usually in costs, where, and I can't remember the name of the case now, many years ago, a party won, got an order for its costs, but then got an offset of £20,000 against those because of the manner in which it had given disclosure.
Excellent. The duty, though, I think for me that could potentially bring about a change is a duty to liaise and cooperate with your opposing counsel. And that is spelt out very clearly in the practice direction, but also in a document called the Disclosure Review Document, the DRD, which seeks to build upon the existing EDQ, requiring the parties to meet, to discuss, and to find ways of conducting disclosure in an efficient way. And it's that express duty to cooperate, which is something that I certainly would be referring to at a case management conference, where you're faced with the other party that has not engaged with you, even though you've sent them your proposals and they've come back and with none of their own. And that does happen routinely. And at the moment, my experience has been that not a lot happens as a result of that. On that cheery topic of sanctions, Colin, we've
kind of touched on it, really. I mean, as Chris has said, I mean, sanctions exist, and they certainly will exist. But I don't want to focus on sanctions. It's a really important part of it that there are sanctions for people behaving in an improper way, whether it's in costs or in other ways. And if they have to be used, they will be used. So at some level, I'm another judge sitting there shaking, that saber rattling, saying these have to be complied with, and if you don't comply with them, sanctions will be visited on you. But I think, as Ed has been saying, I think a really important aspect of all of this is to try and construct a system which means that people, if they do what the rules say, they won't need to be sanctions because they will have to engage with each other. And if they don't engage with each other, I tell you, if you're in my court and it's told you to engage and you haven't done it, then there will be sanctions. And I'm not ashamed to say that, and I'm here, it's public, I'll say so. But it's not the focus of it. It's not meant to be a sort of stick exercise. It really is meant to be a carrot exercise, which is more significant. Now, on our little double act, I've now forgotten whether it's me again or you.
It's me again.
It's you again. All right.
But rather like turkeys voting for Christmas, it was interesting that the biggest part of the feedback, particularly from mid-level associates, was that they wanted more sanctions because they felt that at the moment, it's all very well having duties, but if they haven't got teeth,
sure.
They want it to be set out what sort of sanctions will follow. And those, of course, will be proportionate, but they're there, and I think they're important. There are two parts to two levels of disclosure that might be given at the highest level. There's an idea of something called, we're calling basic disclosure, which is essentially there will be a category of cases, not many, but some, where all you need in the case is frankly the documents on which you're relying. So a bit like arbitration. When you serve your statement of case, you put in those documents that you rely on and that the other side need in order to understand the case they have to meet. So there's no obligation of search, and that's we're calling basic disclosure. Lots of opt-outs for it. Clearly, it may not be appropriate in a very big case where you're going to need a lot more. But for those category of cases, it may actually see that that's all you need to do. So we're hopeful that that proposal of basic disclosure will have some traction, particularly with cases that don't really turn on the documents. The next stage, though, is what we're calling extended disclosure. And I think the key point to make about this is that unlike the existing rules, where I think it's fair to say there is a presumption that you will get an order for disclosure, in relation to extended disclosure, whether that be narrow or very broad, you have to ask for it and you have to justify it. And the way you justify it is by engaging with the other side and explaining very clearly to the court that you've thought through the proposals and setting out what you propose in relation to any particular issue. Colin mentioned the importance of identifying the issues. That's been quite a controversial part of these reforms, because what we're requiring parties to do is, instead of just relying on those lengthy statements of case that raise all sorts of issues, we actually require the solicitors to meet and discuss and draw up a list of issues for disclosure. It could be an issue relating to a particular meeting or event, for example, that granular. But that will then be the focus point for all subsequent discussions, because you can then refer back to the issue when you think about, well, where is the data likely to be held on that? What time period are we talking about? And which custodians? All of those standard questions. But it's a very focused approach. And it does require more work, and it is going to be difficult for parties to agree lists of issues, and they may not always do so. But I think it's absolutely essential that we have that as the starting point before you go any further. And the idea is that you would then link those issues with different types of orders. So under the existing scheme, we have menu options, but under the new scheme, you would have a number of different disclosure models. And I think it's worth touching on those.
So starting from the issues, and I should just adding to what Ed has said about this question of issues, this aspect of doing disclosure based on issues is not a new idea in this jurisdiction. The Intellectual Property Enterprise Court, which I was the first judge of the reformed court in 2010, has been working on that basis for the last 8 years. It's extremely successful. It's litigating quite high value, complex intellectual property disputes in a better way. They're quicker, they're cheaper. Disclosure is given when it's necessary and important, and not when it isn't. And it's all driven by an issues-based approach. But as Ed said, there are then, when you've identified an issue where disclosure is said to be relevant, there's then, I think of it as a slope, a hill. There are 5 models from A, B, C, D, and E, and the higher up the list you want to go, the harder you have to push. And the very top of the hill is traditional Victorian Peruvian guano test, basically the kitchen sink disclosure. And there absolutely are cases where that kind of disclosure is appropriate and necessary. Fraud cases are very often where there'll be issues where, for fraud cases, of course you have to give as full disclosure as one could conceive of. No real difficulty about that. On the other hand, and that's the top of the hill, you do have to justify why that's necessary. And in a proper case, the justification wouldn't be very difficult. At the other end of the hill is no disclosure at all. No one's going to take any persuading to order no disclosure if both sides agree. That's not going to be a problem. And between those two parts on the slope are a series of options. Limited disclosure is B, where you disclose those that you rely on, plus the adverse documents you're aware of. Model C is a request the critical thing about B is no search. So there's no search required at that level. That's near the bottom of the hill, but not at the bottom. In about the middle of the hill is a request search-based disclosure. So there's a list of topics you have to search for, all kinds of documents, and searches have to be done, but again, it's specific. And then higher up, there's broader search-based disclosure, more like what we would have called standard disclosure under the existing system, with an option. One of the options is not to include narrative documents. I mean, one of the standard things that takes place in a disclosure exercise is the production of material which is essentially narrative. And sometimes that's important. I mean, there are cases where it matters, but there are many, many cases where it doesn't. And so identifying that that is a fact, as it were, that sometimes those are necessary and sometimes they're not, is part of this exercise. And somewhere on that slope is the right answer for each issue. And that's the essential structure of the system. And notably, it's not the same as the current menu system, because what happens on the menu system, as I mentioned already, is everyone picks the same thing off the menu. Well, now we have, I don't know, I can't think of a decent metaphor apart from the hill. There's a hill, you've got to push the ball up the hill a bit and justify how high you want to go. And that's important. So what's next? Yes. And the other aspect of this is, and Ed's mentioned this already, is that there will be, as part of this system, a duty to disclose known adverse documents. Now that's quite important. No one is suggesting getting rid of the idea that if a party is aware of documents which are adverse to their case, they can sit on them. It's absolutely not part of this.
Mr. Justice Burst, do people really have that idea that that's on the table for consideration?
The answer is people have thought that the draft proposals might have allowed for the possibility that you could do that. So it's a very important thing that I come along and say, no, it's not. And of course, David, you would never have thought that if you'd read our proposals, but some relatively sensible people have said, well, hang on a minute, you're contemplating a system which doesn't allow for that. So
and I think what it might also do is encourage people to go for those orders like Model A and B and C, in the knowledge that if there is something the other side know about, they can't just sit on it because an order for disclosure hasn't been made or they haven't been asked to disclose it. And that is, of course, the approach that's taken in arbitration. If you're not asked for a particular categories of documents, then you don't have to search for them. You also don't have to disclose the ones you don't like in that category. So.
Chris Dale, your take on it?
On the overall context, it may all sound revolutionary, but actually it is part of an evolution. And if you look back over the Lord Justice Jackson's amendments of 2 or 3 years ago, the practice directions, 31B of a bit before that, and back to 1999, you can see how we've arrived here. We'll look back on this as another and obvious step in the evolution of particularly court control of what is disclosed. Vince Nyko and I, who's sitting in the front row, were involved in the drafting of the practice direction 31B, and both have seared on our brains a fairly senior judge involved in these discussions who said, well, I just send the parties away to sort things out. And you think, no wonder, we've got a problem. There was a judge involved in rulemaking saying he sent people away to sort things out. That it wasn't, effectively washed his hands of it. It wasn't his concern. And that's what we've been getting rid of slowly. And I think probably this new round will be the final nail in judges saying that. Do you think that right, Ed?
I certainly sense that the level of engagement with the judiciary, particularly with the profession, to get this right. I mean, we see this as a mutual opportunity to really bring about a change. And it does require a change both of party attitudes, but also in terms of judicial willingness to intervene. And certainly what I've heard fed back from when there have been discussions about this with the judiciary is that they see this as a very good thing that will make it easier for them to make more bespoke, robust decisions.
I think it's right. I mean, from my perspective as a judge, if I've learned anything as my 8 or 9, whatever it is, years as a judge, it's that case management matters. And that's not a traditional view. I mean, the old-fashioned view is that the job of a judge was to be presented with this perfectly prepared case at the trial and try it and make those
Decide
decisions.
weighty matters of law.
Decide weighty matters, absolutely. And of course, that's obviously part of the job, and maybe the best bit, I don't know. But management of cases is something which is critical, I think, to access to justice. It really is.
I'd like to get Wendy King on this. In the United States in 2015, as some people in the audience know, we amended our federal rules of civil procedure. And one of the big issues that came out of that was the role of the judge in the litigation. Chief Justice John Roberts of the U.S. Supreme Court said that judges have a stewardship role and they need to be actively involved in the litigation process. I don't know how many Maytag washing machines are sold in the United Kingdom, but a lot are sold in the United States, and there used to be a guy, the Maytag repairman, who sat there, and the whole gist of these television commercials was the guy had a very lonely life because the Maytag never broke down, and so he never had anything to repair. Judge Peggy Lean, U.S. magistrate judge, famously said that magistrate judges are not the Maytag repairmen of the judiciary, just waiting for something to do. So on the one hand, we've got the Chief Justice saying, take this active stewardship role, be involved. On the other hand, magistrate judges are saying, hey, we do not need to be babysitting child litigants. Wendy, since 2015, in cases that you've been involved in or your customers, clients, have you seen judges getting more involved?
To some extent, but I think one of the things that we're not addressing here is really that it's a mixed bag, right? I mean, we've got the different perspectives. The client concerned about cost. We have, both the practitioners on the other side of the case have their own perspective. You throw in the technologist, I think it's really confusing. There's a recent case, a decision in June of 2017, very small single plaintiff litigation out of the Eastern District of New York, that I think actually exemplifies one of the issues we don't talk about. You mentioned earlier, why am I sitting here, might be going through my head. The other might be active learning topic is going on over there. very interesting to me. I'm the legal technologist. I get that. Some of this is like speaking Portuguese, but somebody else is speaking Spanish. Similar words, two entirely different languages. But in any event, this case came down to, as you look at the decision, the practitioners went in front of the judge. The judge says, you need to have your meet and confer. You need to come to an agreement on the ESI. They did that, went back in front of them, said, you need to come to an agreement on production and the form of production. They did that. Later, it was a cost burden, shifting of the cost, and the plaintiff had gone back to say that this was very expensive, it was burdensome, they couldn't bear the cost, and the decision was that no meet and confer really took place, no conversations really happened. They probably just exchanged the form. And oftentimes, sitting in my seat supporting the client, we'll get a call, and then it's, I'm going to send you this protocol. I want you to take a look at it. Let me know if you have any issues. You know what? The response is going to be very different if the individual understands from just a technical perspective, is this going to be difficult to produce? Is this going to be difficult to do? Or from a legal perspective. I really think that somewhere there's a disconnect between the processes and the execution, and that understanding in between. There's kind of a lack of a bridge, if you will. So for me, the question isn't, are they getting involved? It's, does everybody actually know and understand how they need to execute it, and in what fashion for the different types of cases that are being presented?
There was that case, wasn't there, in the Alabama Admiralty Court, of all places, about 4 years ago, where lawyers wrote to each other very seriously saying, we're going to use technology-assisted review here. And it rapidly became clear, a bit later on, that none of them had a clue what that expression meant.
Well,
They earnestly agreed to it.
and if you ask a technologist to explain it, and if I start talking about the things that are really fascinating to me, and even things like the coherence, right, and the generality score, the lights go out in Georgia here. Nobody's listening at that point because they don't understand all that techno mumbo jumbo that has a real impact on how quickly you can find the facts, right? And how much you are producing. I'll give a really interesting example besides the fly-by meet and confers that we all know happen, and as you support these cases, how you support them really differs when you've got those good decisions. What if you have it where they've agreed to search terms, and now you as the legal technologist are given those to set them up? And I've looked at one, and it's an actual event where I was looking at it going, these are, the syntax is from LexisNexis Research. Syntax actually doesn't work in this particular database, in this technology. And so you bring it back to the client's attention, and you're like, here's where you'll need to change it to actually get the results you want. Nope. We have agreed to these terms. We are not going back. But you do understand you're going to get considerable larger volumes of documents back, potentially a lot of them that are not relevant. Not going to do it. This is what they've asked for. This is what we've agreed to. This is what you're going to execute. I don't know whether they didn't want to go back because they truly didn't want to go back and go, yeah, we didn't understand that the syntax doesn't work there from a technology and execution perspective, or we've agreed to it. It's just easier. We've checked that box off. Let's just move on.
Mr. Justice Burse, I'm not going to ask you for an advisory opinion, but this scenario Wendy has described occurs before your court. What's your inclination? What's your feeling about getting involved here?
Well, I think funnily enough, there's a part of what Wendy was saying resonates a little bit with some of the proposals which are in what we're working on. And that is to, Ed always remembers the name of this, and I can never remember the name of it, but I think we've called it a disclosure guidance hearing or something. And the idea is, picking up exactly, I think, what Wendy, you've been talking about, is to institutionalize the idea that the courts will convene short, say maximum half-hour, hearings in front of the relevant judge, at which the parties ought to be represented by the people who are actually doing the disclosure. Because one of the experiences which certainly any litigator in the United Kingdom, and I have a strange feeling it probably happens in the US as well, will be familiar with, is you may or may not know the children's nursery rhyme, the king asked the queen and the queen asked the dairymaid, who puts the butter on the royal slice of bread. And what you have in our courts, and I say our, meaning I think common law courts generally, is that the judge, there's a hearing, the parties get the most expensive big cheese advocate, Queen's Counsel in this country or whatever, to speak. Judge asks Queen's Counsel, but Mr. Snooks QC, well, you've searched for and in your search terms. No wonder you have 15 million documents coming up. QC looks blankly at judge, turns to junior counsel, mutter, mutter, mutter. Junior counsel turns to senior solicitor, mutter, mutter. And at the back of the court, there is a young person who knows what's going on.
We hope. Karen Hardy. Mr. Justice Frank Clark, Chief Justice of Ireland, has said that perhaps the rules in Ireland are past their sell-by date, and perhaps there are some changes needed about. Would you care to share what's going on in Ireland at the moment?
Certainly, we're also looking at reforming our discovery rules. We still call it discovery. I sat on a subcommittee recently which has made a proposal to the President of the High Court, which will then go on to the Chief Justice, for a complete reframing of our discovery rules. I'm very interested in quite a lot of what I've heard this morning. I have this image of, you know, the little monkey, the hear no evil, see no evil, in relation to this idea of people producing the stuff they know about which is adverse. You know, the rows that I can envisage about did they know or did they not know about that document fill me with a form of glee, I have to be honest, as a litigator. But in real terms, I think sometimes when we talk about discovery procedure or disclosure procedure, we lose sight of the fact that these documents really matter. I have yet to find a case that didn't turn on the documents, I have to be honest, and I think that effective disclosure is a key part of good, healthy litigation and effective litigation. Discovery, done well, settles cases, and it takes cases out of the court system. So it ought to be done better, and one of the things that informed our discussions around reforming Ireland's discovery rules was the need to refocus and to get back to what this was all about, because actually with changes that had been made to the rules. So for example, in 1999, we went down an issues-based route where they brought in the requirement to seek specific categories of documents. And the idea was that this would get rid of enormous discovery because everything would be focused and people would know what the issues were that they were supposed to be making discovery of. And what happened was we got into a mode, which we are now in, where we devote huge amounts of resources to rowing about what the issues are and what the categories should be. And judges spend interminable days of their career hearing these disputes about what the discovery should be. And so in the committee, we felt it was important to find a system that actually got rid of all of that as far as we could and brought it back and simplified things so that it was more about producing what ought to be produced, what's helpful and harmful, in a frank and full way at the appropriate point in the litigation. And so we've made a number of suggestions. One of the things that we have suggested is that the relevance test should change, and I'm happy to talk about that if you feel that would be of interest to people. So we still have Peruvian guano, the old train of inquiry standard. When we looked at where the costs were coming in discovery, what we discovered was a lot of it was to do with these disputes. But actually, categories themselves, the requirement to specify categories and to identify issues, was resulting in people discovering documents that actually weren't material to the issues because they fell within the category. So you would be agonizing over a 1,000-page spreadsheet that had a single piece of relevant text that was only tangentially relevant, but it fell within one of these categories, so you had an obligation to redact everything but still produce it. And it was completely pointless.
Was it true at the same time that things that didn't fall into the categories could be ignored?
Exactly. So you might have a smoking gun of a document which you wouldn't ever want to rely on, but the other side certainly would like to see it. But if it doesn't fall within one of the categories, then you can hold it back. Now, that's not good for healthy litigation either. So the idea is that what we proposed is that there would be a new test of materiality, and that you would disclose the documents that are material to the issues in dispute as set out in the pleadings. And so we're actually going back to a form of general discovery. So rather than having this very focused approach, which caused all sorts of additional costs and problems, we're proposing that we go back to a basic requirement to produce what's helpful, what's harmful. And we do have a perception, and I know this is something Chris and I have talked about before. In Ireland, we have a perception as practitioners that practitioners here in the UK have a too narrow view of what's relevant. And the reason we have this perception is we deal with in-house counsel very often who are based in London often, who are instructing us in litigation, who argue with us that documents that appear to us to be clearly relevant just aren't relevant and should be excluded. And that is a point of tension for us.
Ed, would you have that debate with Karen?
We haven't had it yet, but I'm
Not
happy
on
to
this
have it.
stage, but I would say it is the case that the Wolf reforms try to restrict the test of relevance, not for something that's, you don't disclose things that are relevant, you disclose things that either support or undermine either party's case. And I think that's still got to be a critical test, because that ultimately is what will help the judge to decide a particular issue. I fully share the concerns about having an issue-based disclosure approach in all cases. What we were thinking about an issue-based disclosure and request-based disclosure is that you might decide that actually there are some critical issues in the dispute that require very extensive disclosure, and that you need to ask the other side to disclose those materials. But it's not all the issues. And we are still maintaining old-style standard disclosure that will enable you to get, the whole array, if that's going to be the most cost-effective way forward. Because I do agree, if we're going to revert to an arbitration-style approach,
Yes.
with massive red fern schedules, those lengthy schedules listing hundreds and hundreds of document requests, that's not the way it should go. I think so. I think that is a challenge. For me, though, the biggest part of the proposals are going to Wendy's point about making sure that there is a proper structure for the discussions to take place by the solicitors, whether they're well informed about e-disclosure or not, with firms like the firms you work with, to make sure right at an early stage you are formulating a sensible approach to e-disclosure. And that's the real problem. At the moment the discussions don't take place, you get an order for disclosure, and then you go away and you discover what a mountain of a problem it is. And everyone produces their data in a different format, and they're applying ridiculous keyword searches, etc. So this modification of the EDQ, the DRD, starts at the most...
Disclosure review document.
Thank you.
Starts at the most basic level of, what are the issues, who are the custodians, what are the date periods, obvious questions. But it then goes on to say, well, how can you use analytics to what's your approach going to be to threading and all the other tools that you can use. But it's not too ambitious at an early stage. It doesn't require the parties to agree keywords, for example, because the feedback we've had is that's much too early. You need to get your data set, test it, and then have a discussion, which may be way later than the case management conference. So that really sort of explains what the DRD is all about, and Chris has been really helpful and others in educating me and others about how this should be structured in a way that might assist you in your roles to make sure that the parties are moving forward in the right direction.
Well,
Karen,
in that context, that Hong Kong took our EDQ and split it into two, more or less copy-pasted words straight from it. You can recognise the language in the Hong Kong one, but they wanted a very high level to begin with, to map out what the scope of the problem was likely to be, with the detail coming in a second stage, which is not a bad way of doing it.
Karen, Mr. Justice Burse has mentioned sanctions, although he didn't want to dwell on it.
Yes.
Ed has mentioned the mid-level associates yearning for stronger sanctions.
Yeah.
What's the current take on sanctions in Ireland?
That's a really good question, David. I think it's very interesting. I've been observing from afar what's been happening in the US and the move away from focus on sanctions, and the sense that if there's too much focus on sanctions, people will discover more material because they're worried about holding stuff back. And so you end up with this sort of data dumping. In Ireland, sanctions have always been a big feature, or the threat of sanction. That's what keeps everybody honest. I think it's generally not a bad thing. But what I've noticed recently when we've been talking about the possibility of new discovery rules, which might change the obligation, I've heard a lot of colleagues, including the Chief Justice, say, well, of course, you would need more severe sanctions if you're going to relax the obligation. And there seems to be a sense of sanctions being a cure-all. I don't personally hold that view, although I will say this. One of the curious things about my experience recently in litigation has been acting for parties where I am against a very small firm that doesn't have any e-discovery expertise, and the court will say, that's just you, Karen Harty, trying to beat up the small firm. If you say, but they haven't searched anything properly, and they say, yeah, but you're an expert, so they can get away with it because they're small, even if their client, in one case, is an international airline who has strategically instructed a small firm, I think for exactly this reason. So there's a slight skewing. I think judges are genuinely in Ireland worried about this inequality of arms point. And as I say, I've had 2 recent outings where I've been hammered because, or at least I didn't get what I wanted. I wasn't hammered, but I didn't get what I wanted. And I should always get what I want.
It's an ambiguous term, of course, to be hammered.
Yeah, it's a bit of an Irish term, apologies. But you know, the client was in a position where the other side had blatantly breached their discovery obligation and had not produced. In one case, they had to produce a further 1,000 documents. Like, this was a big mistake. And they were told, yeah, you're grand because you're a small firm and you couldn't be expected to. So the sanctions threat isn't as severe as it ought to be. I have to say, I suspect that if I made the mistake they had made, I probably would be struck off, because there is a skewing, and big firms with this expertise are expected to do the thing perfectly, which is a bit frustrating.
Chris Dale, thank you, Karen. Karen has described the multinational giant conglomerate with the Trojan horse of litigation, the small firm to hide its ill deeds. Ill deeds go back and forth in litigation, sadly, more often than they should. You are obviously a solicitor based in the UK, trained as such. You spend a lot of time in the US as well. What do you see happening in the UK as far as sanctions go? Do you think that the changes that have gone on in the US may occur in the UK?
We tend to think of sanctions as a punishment handed down by the judge, probably in terms of effectively a fine for conduct to the client. It's actually a wider and deeper problem than that. If you go back to Digicel against Cable and Wireless, which was the case that effectively set us off towards the practice direction 31B, the judge, first hearing the case management conference, effectively said nothing about disclosure. The parties did nothing cooperatively about disclosure until they'd finished, whereupon one objected to the other's keywords and to the other's failure to produce a load of backup tapes and started shouting about it then. Mr. Justice Morgan took the case apart very expertly, decided the keywords for himself, and said, go away and do it properly. It was said, whether I don't know whether it's true or not, that £2 million had already been spent going down what proved to be the wrong path. So the sanction there was being made to redo something. And that was not, as it were, in the form of a penalty, so much as a consequence of not doing it properly. And for that reason, we went down the practice direction 31B route. There's a case called Smales and McNally, which actually Colin Burse heard. Multiple failings. I recommend this judgment, actually. Almost every aspect of e-disclosure failure was covered in this patient judgment that Colin went through. Well, at an earlier hearing, the judge had said, there's a dispute which I cannot resolve, whether agreement to proceed in this way was reached at the meeting. So the poor judge couldn't even detect, despite trying, whether there had been an agreement. And effectively, the whole of the consequences flowed in terms of multiple hearings. And the penalty there was that a £50 million claim was lost purely for disclosure failures. It never got to substantive, fighting the substantive issues. And that was a pretty big sanction, frankly, to lose it on that ground. And there was a side point there that Sir Colin raised, which is effectively this. If you want to allege defects in somebody else's disclosure, you've got to do it properly. You've got to identify what defects it is, which ties in with other developments in the US about just complaining. You've got to be able to show what the problem is. More recently, and on this theme of sanctions because you fouled up your agreement. Triumph Controls, a couple of months ago, Mr. Justice Coulson, there was a disclosure agreement, and one party elected to do their own thing, didn't follow the agreement, which was to use manual review. And the judge said, what they did is not what they said they would do in the EDQ, which promised a manual review of all documents responsive to the keyword searches. Neither is what they did at all clear from their disclosure list. So the criticism there was they'd signed up to an agreement and then gone off and done their own thing. And the judge appears to be so outraged at this that he ended up saying, go away and do manual review. Apparently blessing manual review as the gold standard, which I suspect was an inadvertent.
Gee, that's never happened in any court I've.
Well, quite. That was inadvertent, I think. I don't think he meant to do that. And causing a great deal of expense, and I suspect a great deal of embarrassment to what's actually a very good firm, who had perhaps decided quite rightly that there was a better way of doing it than the way that had been outlined in the order, but neglected to, as it appears anyway, to go and explain that to the other side or go back to the court. There's one last point there, which is I think affects the drafting of these new rules. That's an implicit assumption that you can go back to court if the facts change or if circumstances arise that hadn't been contemplated. That's fine, and perhaps it's fine in the rules building where you might be able to get a hearing. In practice, in a lot of courts in England and Wales, you won't get a hearing for months. So this notional idea that you can just go back to the court to bless a new agreement or to present a different way of doing it is likely to, I think, fail in practice, except in the splendours of the rules building, because you won't find a judge.
Can I ask a question which is slightly on that theme, which is, you mentioned that this had sort of come out of lobbying by the GC 100. And I was interested in that because I think from an Irish perspective, there might be a little bit of concern about the idea of rules being formulated on the basis of business, saying this is the way the rules should be. What about the man on the street and how are they affected if they are in litigation? Because I think plaintiffs, and I don't do plaintiff work other than in commercial litigation, but I think plaintiffs might have the perspective, well, are our interests being served there? Because we would want possibly the ability to get documents from the companies that we're suing. I'm just interested in that. It's not my perspective.
It's a very valid point, and it's a point we sought to stress very clearly in the consultation period when we were telling people about the proposals, that certainly the GC 100 were expressing their concerns, and with good reason, about a particular category of cases. But what we quickly heard is that there were concerns also from all perspectives, from small firms, claimant, defendant, about the problems that we've described. There was certainly quite a lot of pushback and concern at the start that what we were seeking to do was do away with extensive disclosure in all cases. That is not what it's about. It is a key selling point, I consider, of our courts, that you have this ability to get wide-ranging disclosure, but it has to be in the right cases. So a very valid point. And also, I guess on behalf of the LSLA, the London Solicitors Litigation Association, we ran some surveys with the New Law Journal about aspects of disclosure, and again, the feedback was very firmly in that there needs to be a change.
Before we get into closing thoughts, do we have any questions from the audience that you'd like to ask of anyone on the panel in particular, or the entire panel? Oh, yes, right. Do you want to see a lot more sanctions?
It's not really about sanctions for me, it's all about this cooperation point, and particularly the bridge between technology and the lawyers. I think that's really important. But one of the big things we see is the real effort that goes into identifying and then huge collections, and often a lot of expense and time is incurred there, and then you've got hosting fees. So I just wonder if in the new rules they're thinking about looking at issues and having discussions there earlier on about the scope of what will be collected.
Yeah, that is a big problem, because otherwise, as you say, you gather the world because you feel you have to, multiple custodians. So right up front in the disclosure review document, you have questions like, well, who are the key custodians? What are the key dates? And in every section, do you anticipate any particular problems about the proposed, the route that you or the other side propose? So, for example, backup data, corrupted drives, documents in Switzerland, that sort of thing, which those discussions haven't happened before an order's made, and you then have to just deal with the problem. So I think the data collection and discussion about how to interrogate that data is key. Yeah.
Honor,
No avoiding the fact, though, that you've got to spend a certain amount of money in order to be able to articulate to opponents in the court how big the problem is that the court is then going to decide about. And I can't see that there's... one of the interesting things about this round of development is that those planning it have been very upfront about the fact that there will be costs. It's unavoidable that money has got to be spent in getting to the point when you can decide how much money to spend. You see what I mean?
Very quick closing thoughts in our last few minutes. Wendy King, we've had a great point on cooperation from the audience. We've had cooperation as part of the discussion. Since the 2015 rule changes in the US, have you seen more cooperation in the litigation that you do?
Bailed? No. Again, I think there's an effort, but it goes back to the bridge and understanding proportionality, reasonable request, and really what you're asking for. And to sort of tie a bow on what I talked about earlier with that particular case, and going back to even like the sanctions, and it wasn't necessarily a sanction, but it was a consequence of the action of perhaps doing it very quickly in the guise of cooperating, had the meet and confer, exchange the documents, check off the box. The ruling was, clearly you did not actually have a meet and confer. And it wasn't proportional to this actual case, and the decision was interesting because the decision was that 40% of the cost for discovery would be bared by defendant's counsel for the plaintiff's cost, but 60%, the remaining 60% would actually be shifted to plaintiff's counsel. So
Not the litigant, but the counsel.
Yes.
Excellent.
Which was sort of the consequence of their action of not actually taking the time to sit down and have a true meet and confer. And so that's why I say it's sort of veiled. I've done what you've asked me, probably have a standard form sitting back in the office that a really smart, bright associate put together for them. Whatever. And I brought it in and we agreed to it.
Gotcha.
I did what I did, right? Not really.
Karen Hardy, final thoughts.
I think that this point about meet and confer is fascinating, and it's beyond the scope of the time left to talk about it, really, from my perspective, because in Ireland we don't. We don't do it really at all, and I think the bigger commercial firms are not bad at it, actually, and if you have somebody on the other side who understands e-discovery even at a certain level, then you will get some sort of cooperation and understanding, but it generally doesn't happen. And there's a sense that I had one case, in fact, well, I better not mention the name of the case, but I had one case where the other side said, you're trying to get me to agree to stuff so that I can't then bring a motion against you for inadequate discovery later on. So I'm not going to agree anything. And, it's very hard when you get that sort of attitude. So I think we have a way to go.
Gotcha. Chris Dale, final thoughts.
Without abandoning my original motto of RTFR, read the flipping rules, I think the current motto ought to be articulate. Be in a position to persuade perhaps your own client, opponents and the court that what you're suggesting is right, because there's an open field here. You can disclose, we've heard that disclosure can be no disclosure at all. We've heard that it can be old-fashioned Peruvian guano disclosure. It could be anywhere between that if you can articulate why that's right. And to be able to articulate it, you've got to be informed. And that includes not just RTFRing, but also going out and seeing what technology exists and trying to work out how that could help you. And
Ed Cross.
Just 2 points, really. One, I think the rules can only achieve perhaps 40% of the change that's needed. A lot of it's going to come down to what the profession and the judiciary do in practice. The other thing I would just say is see this as a real opportunity for all of you, because there is a massive emphasis on the use of technology in these proposals. it's going to be something that is the default, the expectation of the court. It won't be, should we use technology? It will be, why haven't you thought about how technology can assist? So I think it's a really good opportunity for those here.
And Mr. Justice Burse, on the final word from the judiciary, Chris has gone with the theme of read the expletive rules. And in the United States, we found since the rule change in 2015 that not all judges have followed the rules. I am not going to ask you to say anything about your brethren on the bench, but what's your perspective on judges following the rules?
Well, I mean, I think that's an unanswerable, it's a beautifully put unanswerable question. I mean, as Ed has said, culture is very important in all of this, and I think a lot of what everyone's been saying has borne that out, and that is well understood. It is well understood, and we intend to make sure that the judges, as much as anyone else, are aware of what's going on and understand it and can hopefully apply it as they should. I mean, the other thing I wanted to say, picking up something that Karen had said, which I didn't totally agree with. Karen said, the documents really matter. Some of the documents really matter. And that's what really is the important point.
On behalf of all our panelists today, the 800 some odd employees of Relativity around the world, our partners, all of you for being here, thank you so much. Please join us for the rest of the day. There are more sessions to come. And thanks again. Have a great day.